Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 5 from sections 11 to 16. Next, we are going to see section 11, Res Judicata. What actually res judicata means? We'll try to understand this particular word in a simple way. Let us see what are all the basic requirements under res judicata. But prior to going into those requirements, let us try to understand what is res judicata. If we try to understand in a simple manner, you can imagine if there is a case between A and B and the court has given a decision for a particular property saying that this property belongs to A. Then again, if the same A and B file another case for the same property with the same prayer, whether the court can grant such a prayer? The answer is no. So that is what is res judicata. A matter cannot be decided twice. Same matter between the same parties. The basic requirement is the matter which is directly and substantially in issue. So if you raise some issue which is not directly and substantially an issue, then it is not a problem. For example, in one case, you are claiming the right over a property. In another case, if you are saying that there is a will which is being executed with respect to the same property, if you are asking a prayer that the will should be declared as null and void, then in that case, that is a different case. So the matter should be directly and substantially in issue. That is first point. Then the second requirement is that it should be between the same parties or between parties under whom they or any of them claim. So the first case or the first suit and the second suit should be between the same parties. That is very, very important. And they should be litigating under the same title. So they should have the same title. That is the third point if you see. This case should be in a court competent to try such suit. So the competency of the court is also another issue which you need to understand. And the last requirement is that the court should have heard those cases and completely disposed them. The former suit should have been disposed of. There are some explanations which are given. These explanations are very, very important from exam perspective. In many cases, they will ask, what is the explanation number? They'll give you the explanation and ask what is the explanation number. In some cases, they'll say explanation 3 states that option A, option B, option C and option D. So in all these cases, it is very essential that you should understand the explanation and you should remember the explanation number. That is equally important. The first explanation is the expression former suit. So the former suit denotes a suit which is decided prior. The suit might have been instituted later, but might have been decided earlier. For example, today I am filing a suit. Tomorrow I am filing another suit for the same property with the same prior between the same party. So, if the suit which I am filing tomorrow is decided earlier, that will become the former suit, though it is filed later. So, former suit is one which is decided prior to the suit in question. Next is explanation 2. The competence of a court. Whether a court is competent. We already saw that the court should be competent. Whether the court is competent, the competence of a court shall be determined irrespective of any provisions as to right of appeal from the decision of such court. For example, imagine you have filed a case in a court. If there is a right to appeal from that court, that will not stand as a hindrance to determine the competence of the court. For example, you are filing a case in court X and you are filing an appeal over that case in court Y. So, the opposite party cannot take a defense saying that, see, there is an option of appeal and the appellate court has revised the order or changed the order or reversed the order. Then how can the lower court be competent? That question cannot be raised. That is what is explanation 2. Let us move to explanation 3. If there is a matter which is to be decided in the former suit, or imagine in a case a person is saying some aspect or discussing some matter or saying his side of the case, then in that case the other party should either deny it or admit it. For example, if I am filing a case against you, and in that case, you are denying certain aspects, either the competence of the court or with respect to suit related aspect, we can say like merit related aspect. In those cases, you are denying it. You are saying that what I'm saying is wrong. The next aspect is you can either admit it. You can say like, yes, what he's saying is right. I'm admitting it. This can be expressed or in an implied manner. And the very important thing is, if it is competence of court, it must either be denied or admitted. It is very, very important to be decided in a former suit. It is explanation 3. Let us move to explanation 4. See, the basic fact is, if there is a defense which you have in your favor, or if there is a document or any aspect using which you can attack the case, those two things, the defense and attack in the former suit, will be considered as a matter which is directly and substantially an issue in such suit. Imagine I am defending my case in case X, and there is another case Y with respect to the same aspect between the same parties. Then in that case, I can say to the court that this court cannot entertain this case because this entire case is based on the defense which I took in case X. This case Y is dependent on the defense I took in case X. So this court cannot take this case because it is covered under res judicata. Then explanation 5. If imagine you are asking 5 prayers in the plaint and the court is granting only 4 prayers. Court is silent about the 5th prayer. Court is not saying anything about the prayer. Then it means the court has refused it. That is what you need to presume. Or if the relief claimed in the plaint or the prayer which you are sought for, it is not expressly granted by the decree. It may be in implied manner, but it should be expressly granted. If it is not expressly granted, then it does mean that the court has refused that prayer. Explanation 6. Imagine there is a common pathway, which could be a private pathway or a public pathway. There are 10 people who are using that pathway. So amongst these 10 people, 3 people are going to the court. This path is being blocked by one third party. So all these 10 people are suffering because of this. Out of these 10 people, 3 people go to the court. So what happens is, in this explanation, it is saying that even if 3 people only go to the court, it would be presumed that all the parties, that is all the 10 people, have approached the court because they are people interested in such right. And they also are deemed to have claiming this particular right. Let us move to explanation 7. Now the question is whether the provisions of this particular section, that is section 11, will apply to execution of a decree. The answer is yes. The provisions of this section will apply to execution of a decree also. In this particular explanation, it says that if the word suit, issue or former suit is used anywhere, it would be a reference, it would be construed as a reference to the proceeding for the execution of a decree or questions arising from such proceedings and a former proceeding for the execution of the decree. For example, if you are filing a petition for execution and if a question is arising in that proceeding and it is decided, so that would also be covered under this particular section. Now let us move to explanation 8. Imagine there are 2 cases. There is case X and case Y. Court is Z court. So in Z court, X case is filed. X case is decided by the court. Then the Y case is filed with respect to the same cause of action, with respect to the same issue between the same parties with the same prayer. So in that case, even if the court was incompetent to decide the case Y, the X case will still operate as a res judicata. Let us move to section 12. Bar to further suit. If a plaintiff is specifically precluded, that is, he is restricted by rules from instituting a further suit with respect to a particular cause of action, he cannot file a suit. To put it in a simple manner, if a person is restricted by rules from filing another case for a particular cause of action, he cannot file it. Now let us see section 13. When foreign judgment not conclusive. generally foreign judgment is conclusive if it is between the same parties or parties under whom they or any of them claim litigating under the same title. Two situations between the same parties or parties who are having a same title. Under certain situations, the foreign judgment will not be conclusive. When? First is if the court is not of a competent jurisdiction. Second is if the judgment is not given on merits of the case. Third is if the court which decided, the foreign court which decided the case, has an incorrect view of international law or it refuses to recognize the law of India. In that case, the judgment will not be conclusive. And the fourth point or D point is when the judgment is opposed to natural justice. Natural justice is not rendered by the judgment. In that case, it cannot be conclusive. And if the judgment has been obtained by fraud, it cannot be binding or it is not conclusive. That is the point number E. And point number F is if specifically there is a claim which is based on breach of any law in force in India, that is, the law has been breached. Now let us move to section 14, presumption as to foreign judgments. And generally, even in our courts, if we give a certified copy to any court of a judgment, the court will presume that it is a judgment which is given by a competent court. So the same thing applies to foreign judgment also. If a foreign court is giving a judgment and you obtain a certified copy of that foreign judgment, then it is presumed that the judgment was given by a court of competent jurisdiction unless the contrary is proved or appears on record. But the presumption can be removed for want of jurisdiction. For example, if there is a foreign court which has given a judgment, if that court has no jurisdiction, then this presumption will not lie. For example, if there is a dispute between parties in America, USA, United States of America, and the parties are residing there, say one of the parties is an Indian citizen, he has signed an agreement saying that if any dispute comes, it shall be decided in US. And the transaction took place in US, the parties are residing in US, the company was started in US, the dispute came in US, everything came in US. But the case is filed in, say, Mexico. Then in that case, Mexico court has no jurisdiction to enter in this case. Then that judgment cannot be considered as valid. Next is place of suing. Section 15 says courts in which suits to be instituted. In which court you have to institute a suit. So whenever you file a civil case, you should file it in the lowest grade court. Now let us move to section 16. Suits to be instituted where subject matter is situated. Generally, wherever the subject matter is situated, court having jurisdiction with respect to that area where the subject matter is situated, you can file a case. However, that is subject to the pecuniary or other limitations prescribed by any law. For example, if it is 1 lakh, you can file in this court, say A court. And if it is more than 1 lakh, you need to file in B court. So these aspects are also to be considered. And if it is with respect to immovable property with or without rent or profits, and if it is for partition of immovable property, you need to file the case where the subject matter or the property is situated. Point C. For foreclosure, sale or redemption in the case of a mortgage. For example, if there is a mortgage or charge on a immovable property, then you have to file the case where the property is situated or in the court which has a jurisdiction over the property or the area where the property is situated. Then let us move to point D. If there is a right or interest with respect to an immovable property, if there is immovable property and somebody is fighting for a right over that property, then in that case also the case should be filed in a place where the property is situated or the court which has jurisdiction over the place where the property is situated. And if it is for wrong to any immovable property and somebody is seeking compensation for any wrong committed to the immovable property, even in that case, the case should be filed in the place where the immovable property is situated. Let us move to point F. For the recovery of movable property actually under distraint or attachment, if the property is a movable property and it is attached, then in that case, where the property is situated, the court within local limits of whose jurisdiction the property is situated, you need to file the case there. In case we are filing a case to obtain a personal obedience of the defendant, so the court is saying you have to do this. In that case, where you can file the case, you can file it where the property is situated or within local limits of whose jurisdiction the defendant actually is residing, or where he is carrying on his business, or where he works for gain. Particularly in this section, property means property situated in India only. If it is a property situated outside India, it is not covered under this section. Finally, press the thumbs up button and like the video. If you have anything to say about this video, please do put that in the comment, and don't forget to subscribe and press the bell icon, and certainly do share this channel with your friends. Let us join hands together and contribute for a learned society. Thank you.